Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain unallocated support in Illinois divorce cases. We'll explain what unallocated support is and the change that happened in 2019 and how that change affects unallocated support orders that were entered prior to 2019. So first, unallocated support is the combination of child support and spousal maintenance into one lump sum payment, and we call this payment unallocated support. So it's a lump sum that is not divided between child support and spousal maintenance. It's combining what would otherwise be paid as each of those two things into one payment of unallocated support. The reason people would do this in divorce cases prior to 2019 is because it is tax efficient, meaning more money was staying between the two spouses that were getting divorced and less was going to the federal government and taxes. I'll explain how this works. So prior to 2019, spousal maintenance payments were tax deductible to the payor. Child support payments were not. So that means that the more you could call spousal maintenance, the better tax treatment you were going to get because the payor was in a higher income bracket generally than the recipient. Because they'd be taxed at a higher rate than the recipient, the more you could make tax deductible to the payor, the better. The more there would be to go around to both of the parties that were getting divorced. So the idea is, since child support was not tax deductible, you combine child support into spousal maintenance and call it unallocated support, and it all becomes tax deductible. The child support that you would otherwise not be able to deduct from your income if you're the payor is now tax deductible as unallocated support. And again, the reason you do this is because the payor is in a higher income bracket and you want to award the recipient more in support without hurting the payor. It's no skin off the payor's nose if you can find a way to make it more tax efficient and have it all be tax deductible. The payor's not really paying any more than they otherwise would if you called it child support. It's just the government is getting less in taxes. Everybody wins. The payor's not paying anymore. The recipient makes more in support payments. The government is the loser. They're getting less in taxes. So for high-earning couples, especially when the payor was in a very high tax bracket, it made a ton of sense for everyone to agree to, rather than paying separate child support and spousal maintenance payments, pay one lump sum payment in unallocated support, and the sum of the parts is greater than the parts, really, because you're going to end up with a higher unallocated support payment than you would if you just added up what would otherwise be the child support and spousal maintenance payments, because you could make it a higher amount because of the tax efficiency. So that's why people did it. But because the government was losing out on taxes, or for whatever reason, the government changed the law in 2019. They did away with unallocated support for divorce orders that were entered after January 1st, 2019. They also made it so spousal maintenance payments were no longer tax deductible to the payor. So the big question is, if you had a divorce order that was entered prior to January 1, 2019, and you now, after 2019, want to go back and modify the amount of unallocated support in that order, what happens? Which law applies? The old law that allowed the favorable tax treatment and allowed for unallocated support, or the new post-2019 law that does not allow unallocated support to exist at all and does not give favorable tax treatment, does not allow spousal maintenance to be tax deductible to the payor? Well, the answer is that it's up to the parties. The parties can agree to have the pre-2019 law apply. So even though if there's a substantial change in circumstances, they can go back and modify their unallocated support that was entered prior to 2019, the amount might go up or down that's paid in unallocated support, but they can use the old law prior to 2019 to make sure that that amount is still tax deductible to the payor and receiving favorable tax treatment. And it doesn't have to be broken up into child support and spousal maintenance as it would if the divorce were entered after 2019. If the parties can't agree to have the old law apply, then the new law will apply and they'll lose tax efficiency and it'll be broken up between child support and spousal maintenance. Basically, if it was a good idea to have unallocated support prior to 2019 when your divorce order was entered, it's probably still a good idea to keep it that way because it will still be tax efficient. There will still be more in the pie to go around, and tax efficiency is one of the considerations that courts use to determine how much to award in support, whether it's spousal maintenance, child support, or unallocated support. So again, the bottom line is that although unallocated support is no longer available to divorces that are entered after 2019, and although neither unallocated support nor spousal maintenance is tax deductible for divorces that were entered after January 1st, 2019. As long as your divorce order was entered prior to that date, your final order in your divorce, you can still take advantage of the old law if you go back and modify the unallocated support. So if you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. If you would like to subscribe, we'd love that. It would be helpful to us. Subscribe to us on YouTube, Apple Podcasts, SoundCloud, wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.